Yes.
I was asked before the short adjournment whether there's any old document relevant to issue 2 that wasn't referred to by the judge in his assessment. Can I ask you to look at these at paragraph 98 on page 126 of the judgment. And it's an email from Mr. Brady of 27th of January, 5 lines in, and he refers to the bottom of that email to IS making a firm stance on some of the issues around related pay, favourable structured deals and tax. Now the tax problem was nothing to do with Mr. Soames at all. It was a Esken problem, not a Stobart Capital problem, and of course if the judge was properly looking at all the evidence as to the extent to which Mr. Brady was keeping Mr. Soames in the loop, he would have addressed this under issue 2.
So have I got the right document? Paragraph 98?
Yes, it's the last 2 lines of the quote.
Oh, right.
Sorry. With IS making a firm stance on some of the issues around related party, favourable structured deals and tax. And a document I missed in respect of issue 1 that I ought to have drawn to your attention, an old document, is at 95. On page 125. Mr. Brown wrote back stating he thought that Mr. Foster was the right person and that SGL had all the cards. He also stated that we need to ensure that defeat is not snatched from the jaws of victory. And that's something the judge should have addressed when asking himself the answer to the first question, clearly relevant material that needed to be evaluated. Now I know my Lord Justice Snowden will turn around to me and say, well look, they've cited cross-examination and therefore that's all swept up in 2553, but having had another look at 255 over the short adjournment, I would submit that it's quite clear from the introduction of 255 that the judge is asking himself the wrong question. He's not asking himself, was there a plan, by addressing both the old and new document. He was asking himself the question, do the new document demonstrate that there was a plan? And therefore, to the extent to which he had regard to any cross-examination in subparagraph 3, it's quite clear he's doing so in relation to a question that is not the right question and it is unduly narrow. I've been over this ground before, but that is my definitive answer, if I may say so, to the questions I was asked about 255. The judge was clearly asking himself the wrong question. The explanation as to why he was asking himself the wrong question can be found from paragraphs 33, 34, 35 and 221 as expanded upon in the consequential judgment. Lord Justice Popplewell asked me a question as to what it was the judge was accepting. And we say that a fair reading of the judgment, that the judge's approach was to accept Judge Russell's findings unless the new evidence demonstrated otherwise. That's the first point. In the course of evaluating the new evidence, his starting point was to look at what Judge Russell had found and placed weight on it, unless the new evidence told him or demonstrated conclusively that he was wrong to do so. And thirdly, where there was no new evidence on a particular issue or sub-issue, the judge felt constrained to accept what Judge Russell had found. And that's absolutely clear from 33, 34, and in particular the last few lines of 35 that I drew to your attention just before the short adjournment.
I think it does follow from your submissions that you say the approach of a judge on a trial of a claim to set aside an earlier judgment for fraud must be to retry all the allegations, all the issues in the first case by reference to the entirety of the documentation then available.
No, I don't, because there's no allegation of fraud in the first cases. It's a different cause of action and different issue.
But how your criticism of the judge in this case is that he, Mr. Justice Leech, is that he took as read findings made by His Honour Judge Russon.
But you can't do that.
I know you say they can't do that, so the only logical other way of doing it is to try all the issues that were in front of Judge Russon again.
No, try the issues that were before Judge Russon that are relevant to the new cause of action. And
Well, they all are on your case, because they all involve questions of the credibility of witness, even in relation to issues which aren't allegations of fraud before Judge Russell.
Oh.
The issues of the credibility of the witnesses arose, and your case, as I understand it, is that any issue, any evidence which went to the credibility of any of these four critical witnesses was a matter that was in issue and needed to be addressed for the purposes of the set-aside claim before Mr. Justice Leech.
yes.
So that does involve, doesn't it, everything that was before Judge Russon?
No, because we weren't putting before Judge Leech everything that was before Judge Russon. We were putting forward the material that we believed was relevant to the decision as to whether or not the judgment had been obtained by fraud. And the judge only needed to look at that material. He did not need to and should not have gone outside it, which is why I made the criticism when he relied on the intimidating text from Mr. Walwell. He shouldn't have gone anywhere near that.
When you say the material you put before Mr. Justice Leech, do you mean the allegations you pursued before Mr.
Yes.
Justice Leech? Because I understand it, the entirety of the material was put before him.
Well, the original trial bundle was there. It doesn't mean it was put before him. What was put before him was my cross-examination of their witnesses and the documents I relied on, both old and new,
Yes.
when cross-examining. And all he needed to do is to evaluate that material. So I'm not imposing a high threshold. It's a very high threshold to establish fraud. I completely accept that. And I completely accept the judge should only find dishonesty with the compelling evidence. But the judge's task is no different from any other judge determining an issue. It's a different cause of action. Now, in our skeleton argument, we give 5 reasons as to why the approach was wrong, which I'll develop orally, if I may. The first and most fundamental is because it is at odds with the nature and basis of a claim to set aside a judgment for fraud.
Sorry, just before you start on this legal aspect, can I slow you down by asking you one other
Of course,
question? By reference to the pleadings and the re-amended particulars of claim, if that's the right version,
yes,
behind tab 11 in the core
Yes.
law. And it's section G, which starts at page 383.
yes,
And it is the section that is headed the false evidence, and then over the page, first of all, has what's alleged to be Mr. Brady's false evidence, and then Mr. Soames and Mr. Coombs and Mr. Ferguson in
yes,
sections. And that is introduced at paragraph 77 by the introduction that the Mr. Soames ET disclosure, and in particular the critical undisclosed documents,
yes,
so that's what we've been calling the new material,
yes,
show that at the very least Mr. Brady, Mr. Soames and Mr. Ferguson all gave false evidence to the court as set out more particularly below.
yes.
Now, is that the right approach? That you look at the new documents and see whether they show that they gave false evidence in
have
those
to-
respects?
Because the cause of action requires you to plead the new documents, you have to plead them. But when you come to try making a decision on the relevant findings, you have to look at the old and new material. And the judge wasn't taking a pleading point against me. The judge was taking a point as which was a principled approach.
No, but I'm asking you. Does paragraph 77 accurately reflect the exercise the judge ought to have been undertaking? Or is it, as I think you're now submitting to us, that it was the new material and all the old material,
Yes.
all the relevant old material, show that they gave false evidence?
And that's how it was the latter, and that's how the case was opened and closed without any objection below. The objection was one of principle, not of pleading.
So the way it's pleaded isn't right, but you shouldn't be limited to that because it was opened and advanced
Because it was opened
outside the pleading.
It was opened that way, it was run that way, it was closed that way, and it wasn't criticised by reference to the pleading. It wasn't said that I can't go beyond it by reference to pleading. It was said as a matter of approach, as we've seen, and I don't want to repeat paragraphs 33 to 35. You've seen the judge setting out the fundamental differences of approach, is how he put it.
Thank you.
So do you plead any of the old
Yes, we
documents?
did. Yes, we did. I took you to that this morning. Do you want to go back to it?
Back at 11.
Yes, exactly. And the reason it was pleaded like this is because the constituent part of the cause of action is to demonstrate the new material.
Is there a convenient list somewhere of the? You said in answer to my earlier question, no, the judge doesn't need to completely retry the first trial. The second judge doesn't retry the first trial. He only has to focus on the issues in the second case.
Yes.
Was there a list for the judge of the issues in the case which you say he had to retry afresh using all the evidence?
Well, I think it's paragraph 219 is the starting point. And in our closing submissions, we brought in any sub-issue that was relevant to the main issues in 219.
But you said a moment ago that the case was opened, run and closed on the basis that the judge should retry the issues on the full evidence.
Yes.
And I'm just trying to identify where, in a sense, you said from the start to the judge, the way you need to go about this is these are the issues in this case in front of you, which you now need to determine, but on the basis of all the evidence.
Well, we haven't got our openings before you, but if you go back, please, to paragraph 28
Of what?
of the judgment, page 101.
Well, that records your submission that you said that.
Exactly.
28.
Yes.
Okay, that says in closing.
Yes.
Right. What I was after was how, in a sense, did you say to the judge throughout the trial, what you need to do is you need to try these issues afresh?
I believe I did. I haven't got my opening, or my oral opening to give you a transcript reference, but I believe I did, yes.
But you identified all the issues which needed to have that approach applied to them.
Yes. And when we closed, when we identified each issue, we listed all the material that the judge should have regard to, which is new and old. But when we get to his analysis, we just get the new, with one or two exceptions.
I mean, what I'm slightly troubled by, Mr. Wardell, is the legal position. I know it's a bit eccentric to be concerned about that, but in an action to set aside a judgment, it's a fraud action, isn't it?
Yes, it is.
So is it an action for fraudulent misrepresentation, effectively? So what's being said is there was a representation, evidence given to the court, which was false. So first, you have to show what was said. Secondly, you have to show it was false. Thirdly, you have to show it was material and relied upon. And I suppose damage follows automatically because you've got a judgment against you shouldn't have. Now, on that analysis, the concentration would be on the representation that was falsely made to the court, namely your pleading at page, whatever it is, 393, this is what evidence they gave that was false. How does that mean that you have to retry the whole issue? I mean, where does that come from?
Well, you have to address your mind to any material which is relied upon as demonstrating conscious and deliberate dishonesty at the first trial. That's the scope of the exercise.
So it's at the second stage, after you plead the falsity, that you plead the representation, And at the second stage, you have to prove that was deliberate and dishonest, a slightly higher test than fraudulent misrepresentation. But you have to prove that, and as part of that, to decide if it was fraudulent, you have to look at everything and re-evaluate all the issues before the judge.
No, not all the issues. No, you have to...
All the relevant issues.
All the relevant issues that goes to the honesty or otherwise of what they were saying. So, an important plank of our case, as you know, was that there was a plan to oust. Mm-hmm. And that was important for Judge Russon's reasoning, because one of the things he had to address was whether the power under 89.5 had been exercised for an improper or proper purpose. And we said that when you looked at all the new material and the old material, it was quite clear there was a plan in January and February 18 to oust him before any misconduct or alleged misconduct came to light. Ergo, if the judge known about this, he would have approached the evidence differently. That's a materiality point. So when proving conscious and deliberate dishonesty, I'm entitled, on behalf of the claimant, to adduce such evidence as we say is material to the decision the judge has to make on that. And I'm just sort of like pausing about putting it as a limiting it to misrepresentation. It may come to the same thing, but it is, was the conduct of the trial and the evidence given and the documents not disclosed, does that demonstrate conscious and deliberate dishonesty on the part of the other party? I mean, we could again end up with an interesting debate of what happens if a party deliberately destroys all its relevant documents, but in the end, it's not quite so clear cut to what extent it.
Then you're making a representation to the court that you've given proper disclosure.
If you put it that wide, then I don't quarrel with that. So
I mean, you have to have a cause of action, right?
Yes, we do.
And you have to have one that's known to the law.
It is, and the ingredients of the cause of action are just twofold: conscious and deliberate dishonesty, and materiality. That's
well,
it.
No, those are the elements of the cause of action, not the cause of action. The cause of action, I think, is in fraudulent misrepresentation.
Yes, it's not how it's
and otherwise it would be a conspiracy. Maybe but you tried to advance somewhere a conspiracy case, didn't you? And that fell by the wayside.
I couldn't unless and until I won on the setting aside the judgment.
Yes. So I think it's fraud.
It is fraud, for sure.
We talk about fraud for short, but
yes.
under civil law, fraud means fraudulent misrepresentation.
Yes.
And so that's what we're testing it against.
Yes.
And what I'm asking is, the elements of fraud are pretty well known: representation, false, material, reliance, damage.
Yes.
Where's retry all the issues in the case?
You're not retrying all
the relevant issues.
You're addressing those points that go to whether or not dishonest evidence was given.
You say it's under dishonesty.
Yeah.
Yeah. Okay.
It's false evidence, and then was it dishonest? Yes.
Let's look at your 5 reasons why the judge was wrong, because they may help us as well.
First of all, it's the nature of.
So, which para is it in your skeleton?
I think it might be paragraph 27. I'm not.
Yes. Mm-hmm.
So, the starting point is this a procedural application or is it a cause of action? And we start by looking at Lord Sumption and Tackar.
Well, I think we know that it's a cause of action, and
Yes.
he said so, and we wouldn't have the temerity to say that he was wrong.
No. But what we say flows.
It's actually
from
said to be an equitable jurisdiction, isn't it?
Yeah.
Yeah.
What's the equitable cause of action?
What he says he said that, as I recall, that one has a substantive right to set aside a judgment that has been obtained by fraud.
Well,
And he says it's a cause of action.
What page is it in the authorities book?
It's on page 831, tab 15 for those looking at hard copies.
I'm always a bit suspicious of equitable causes of action. 831.
831, indeed.
61, is it?
Yes. And where it says this. Sorry, my computer's
So equity has always exercised a special jurisdiction to reverse. He's talking about rescission there. And equity's jurisdiction to reverse transactions procured by fraud. So, but that is a remedy,
Yes.
strictly so called, for fraudulent misrepresentation.
Yes.
Okay.
And it's an independent cause of action, relates to the conduct of the earlier proceedings. No question of cause of action estoppel, no question of issue estoppel, because the basis of the action is that the decision of the issue in the earlier proceedings is vitiated by the fraud and cannot bind the parties. If the claimant establishes his right to have the early judgment set aside, it will be of no further legal relevance. And we say the number of obvious but important consequences flow from this. First of all, it's a cause of action that's entirely separate to and independent of the cause of action in the original proceedings. Secondly, whatever the impugned judgment decided is of no relevance when deciding whether there's conscious and deliberate dishonesty, precisely because the basis of the action is that the judgment is vitiated by fraud.
Yeah, but you haven't proved that. That's just your claim.
Of course.
There is an element of bootstraps in
No element of bootstraps in my approach. Huge element of bootstraps in the approach that Judge Leech adopted.
Let's call him Mr. Justice.
Mr. Judge, I do apologise.
Shall we?
Yes, I didn't mean to be discourteous to the
I
judge.
think he's entitled at least
Of
to
course.
that.
My apologies.
So you claim fraud and the right to set aside the judgment on the basis of fraud.
If I establish it.
Yes, but we're looking at the question at the moment about the mechanism by which you have to establish it.
Well, I establish it by adducing whatever evidence I consider appropriate to make good that plea. And the judge has to decide.
But until the judgment is set aside, because you have established that it was procured by fraud, it stands as a judgment. I'm just querying the logic of your particular argument in this respect. You say because your case is premised upon an assertion that the judgment was procured by fraud, you can't, when trying that second action, have any place any reliance upon the first judgment, which presupposes that which you need to prove.
No, it just is. It begs the question. Turning it around the other way, let's say the judgment had been obtained by fraud. Any judge, when deciding that issue, who places weight on the original judgment, risks placing weight on something that's vitiated by fraud.
Yes, but if the judge is aware that that's, in a sense, that is your case,
then that's why it's absolutely essential that he approaches it from first principles and decides the case on the evidence before him.
but does that necessitate him adopting the approach of having to retry afresh all the allegations, as opposed to asking himself the question, first of all, was this new evidence concealed, and if so, what difference would it have made?
It's not retrying all the. I think we've been over this ground, and my position is that it's not retrying all the issues. It's retrying those issues that justify the conclusion of fraud. It's as simple as that.
You see, can we look? Would you mind looking with me at the Amptill-Perridge case,
Yeah.
just for a moment, at page 925, because there,
It's tab 17 for everyone else.
yes,
925.
925.
Thank you.
It's at page 591 in the report, in the judgment of Lord Simon. And he refers to the case of Flower and Lloyd, which is the case on which Lord Sumption relies for the equitable jurisdiction point. And I think the judgment was of George Jessel, Master of the Rolls, who cited Lord Redesdale, saying, have you got it at letter E?
Yes.
The fraud used in obtaining the decree being the principal point in issue and necessary to be established by proof before the propriety of the decree can be investigated. So you start from the question of the fraud you're trying to prove, which rather supports the point I put to you. This is a cause of action in fraud. You you prove the representation. You prove it was fraudulent.
Yes.
and then you come on to see the effects and the materiality, etc. That doesn't sort of indicate that you take the issues at issue in the original judgment first and try those.
Well, it all depends what you need to.
The ones that are challenged. I think my Lord's point about bootstraps is that you can't start in a fraud case by assuming what you set out to prove, which is that the judgment was obtained by fraud.
I'm not.
The first thing, as Lord Redesdale said, and I don't know in which, oh yes, he said this in before 1877, but we don't know in what case, I don't think. Maybe we do. Anyway, you can't start, you have to prove the fraud first, is the point I'm making.
But I agree with that.
Yeah.
But in doing so, you have to look at your proof of fraud will rely on certain stepping stones, certain necessary prior facts, one of which was there a plan. If there was a plan, then I prove fraud. Because if there was a plan...
Because they said there wasn't.
What?
Because they said there wasn't.
Exactly. And they concealed documents showing that there was a plan.
Okay.
Well, they said that there was no intention to oust Mr. Tinkler in January and February. And we said that the old and new documents taken together showed that there was. And that, if we got home on that, that would prove fraud.
Yeah. Okay.
So, I think I'm advocating for a neutral stance. I don't think, if I may say so, that the new judge, Mr. Justice Leech, should make any assumption about the correctness or otherwise of the original decision. The new judge, he or she, should address the material before the court and ask themselves the question, was the court misled? Was the judgment obtained by fraud? In that event, no cause of action, no issue of estoppel. If in evaluating that first question, which Lord Justice Snowden suggests to me that might be an appropriate approach, I would say that is a bootstraps argument. Because fraud taints all. If there is fraud, no reliance can be placed on the original judgment. You can't therefore assess whether or not the original judgment has been obtained by fraud by making any assumptions about the correctness of the original decision.
So you say what the second judge needs to do is to say, on the identified issues which the claimant will identify as having been materially affected by the alleged fraud,
yes.
I must try all those issues again.
Yes.
Compare my result to the first instance judgment. If it's different, I then need to decide why it was different. My answer is different than the first trial judge. And I need to then answer the question, is my answer different because of the new documents?
Yeah.
And if you answer yes, I then need to decide whether those documents were withheld or suppressed deliberately and dishonestly, whatever the expression is.
And it's not just the new doc. I'm sorry.
And so, does it work from that end
Yes.
of the equation, or the telescope, as I think it might be?
Exactly that. So it's not just is the evidence false because of the new document. Have I reached a different view because of the new documents? But also then, did they deliberately give false evidence on that particular issue? And at that stage,
your case is that doesn't have to be referable to the new documents at all. At that stage, I think your case is that the judge too, having identified the issues he has to decide, can decide that there has been false evidence given solely on the basis of the old material.
I don't think I'd go that far.
Well, why not?
And the reason I wouldn't go that far is I think I would have to accept that the new material, the material that wasn't deployed, has to be, I've used material twice, has to be relevant to the issues you're raising. So if it turned out at the end of the trial that someone had brought a fraud claim on the basis that the relevant new material had been obtained that wasn't deployed below, and the trial judge at the end of all of this decides that the new material is not relevant at all to the question of dishonesty in the first trial. I'm not sure on what basis you could set aside the old judgment. It's that you have to have new material that's relevant to the issue of whether or not there's been honest evidence. And we say we easily satisfied that.
So, if the judge retries the issues on the basis of all the evidence, and it's a credibility question, say, and he says, actually, having heard the evidence of the witnesses, I don't believe Mr. X, I find differently to the first judge on a particular issue. He then has to decide why it is that he's reached a different conclusion.
Yes.
And unless he can answer the question, is the reason that you have reached a different view because of something that has only just come to light, you say he can't set aside the first judgment for fraud, even though his decision is different. I mean, that's a very difficult analytical exercise to do in that way, isn't it?
Well, I think I would struggle. I mean, why I'm hesitating about your questions about this, it seems to me that the cause of action requires you to adduce new material that wasn't deployed below. And it must be, I would suggest, new material that's relevant
Yes,
to the,
but it
to the
may
question
not,
of dishonesty.
true, but it may not be the reason why the second judge reaches a different conclusion on a particular issue. In the second retrial, I'm trying to just understand the practicalities of the way you say the judge should have approached this and what flows from it. And I think, as I understand it, you're saying you must, as a judge, start without any preconception that the first judge was right on the relevant issues.
Yes.
So you try the relevant issues by reference to all the material,
Yes.
old and new. You reach a conclusion. If it's the same as the first judge, then by definition,
Game over.
Game over. If it's different, then I think your analysis is that the second judge has to say, why have I reached a different conclusion on this issue or these issues than the first judge? And it's only if he can say, because of some new material, that he proceeds to the rest of the analysis. Because if he just...
If I said that, I misspoke. What I meant is that having reached a different view, he then asked himself, was the judgment first time round on this particular issue or issues obtained by deliberate dishonesty?
Well, the only reason he's going to know that is because your hypothesis is that the true decision is the second judge's decision on all the evidence.
Because he's got more material.
So that he then has to ask the question, was the first judge, did he reach the contrary conclusion because he was misled? To use
was
it,
the conscious and deliberate dishonesty? Absolutely.
by the concealment or the false evidence or whatever.
Exactly. But that's not a difficult task. If you've got new material that shows the original material should be looked at in a different light.
But it is putting the cart slightly before the horse. Because if you start by trying the issue, the relevant issue, was there a plan, and then you ask a lot of rather complicated questions about whether your decision on the relevant plan was different from the judge's because of X, Y, or Z, that's slightly counterintuitive when, even if there is some magical equitable right to set aside a judgment, which is all pre-fusion of law and equity according to these cases I've now looked at, even if that's the case, it must be a simple case of fraud, and you must have to show the basic elements of fraud, namely that there was a fraud,
Yes.
and that somebody was misled by it, relied on it, and it was material. Why don't you just do that? Why don't, in a fraud action, as Lord Sumption says in very clear terms, in TACAR, you start by trying it as a fraud action.
Yes. I thought that's all I was saying.
Well, I don't think it is what you're saying.
Well, maybe
you're resisting my Lord's suggestion that you can't possibly start by trying one of the issues in the other case, because if you do that, you assume that that judgment was obtained by fraud before you prove that.
No, you can try the issues, but you shouldn't rely on what the judge found. That's all I'm saying.
I know, but you're resisting you're resisting the proposition that the starting point is prove the fraud.
I'm not at all.
Okay.
I absolutely accept that that's the starting point.
Right. So it's nothing to do with trying whether there was a plan. It's trying whether the principles that you plead that were dishonestly spoken were dishonestly spoken. In other words, paragraph 79 of your pleading rather than paragraph 11.
But inextricably linked with that was there a plan, and is the destruction or concealment of documents.
Yeah, but although you, and this is because you say the linkage is, the reason, if you establish there was a plan, that's a reason why they may have concealed documents to get over it. But I mean, in a sense, that will always be the case, won't it? Because in almost every case, people will only conceal, destroy, or give false evidence because they think it's relevant to an issue in the case.
Yeah.
So almost inevitably, you are going to get into this conundrum where, in order to decide whether there was dishonesty, concealment, destruction of documents, or perjury, whatever, you have to try the actual underlying issue to decide whether there was a plan or whatever the issue is, which you say is the motivation for destroying documents. So inevitably you have to get into a sort of circle.
Well, some cases are much easier than others. I mean, in some cases, like the Takar case itself, it's very simple because the forgery was discovered after the event. Well, I didn't really need to get back into the issues that the first trial judge had to address. But here, when you've got, as I said earlier, pieces of the jigsaw, and you get many more pieces of the jigsaw, which puts the whole picture in a different light, there is inevitably a need to traverse.
But in the pieces of the jigsaw case, and then I think we must let you get on, it is different, as you point out, but there is an even more importance in the finality of litigation, because where there are pieces of a jigsaw, particularly when it's a very large jigsaw, you could have adduced evidence, both sides chose to adduce the evidence they did, and there may be whole rafts of things that could have been brought before the court before, but people have to be bound absent a proven fraud.
Absolutely.
Yeah. And I think you're agreeing with me anyway, that that's the key question. Was there a fraud perpetrated on the court, either by destruction or withholding of documents that ought to have been disclosed, or by false evidence? And that's the first thing the judge should have been deciding.
Yeah.
And you say the way he decided that was wrong.
Yeah.
Okay, but I think we're going to have to let you get on because you've only got really another hour left or so, and
Yes.
you've got probably a bit of ground to
A
cover.
bit of ground to cover. I was just going to draw your attention to what Lord Briggs says in
Takar.
Takar, paragraph 84, page 839.
Was he in the majority or dissenting?
He wasn't in the majority.
Was he dissenting?
No, he agreed, but he was arguing for a rather more flexible test.
Okay. So he's not, it's not really, okay, which paragraph?
It's paragraph 84.
Yeah.
Not, in my view, no answer to this analysis to say the application to set aside a judgment for fraud not previously alleged will not of itself relitigate anything, so that the finality principle is not thereby really engaged at all. The overall objective is relitigation. The forensic pursuit in defence of the fraud allegation may well travel over, or at least overlap, with ground trampled on the original proceedings. Sometimes it's inevitable you cover the same ground, but you're doing so for a different purpose, to answer a different question.
Mm-hmm. Yep.
I mean, it's the sentence at E beginning, even if it does not, and that's his view.
Yes.
Which is the relitigation point, put it a slightly different way, isn't it?
Yes. And the risk of repeating myself, Judge Mr. Justice Leech clearly understood the importance of Mr. Tinkler's case about being a plan to the question of dishonesty, which is why he acknowledged it was a central plank in paragraph 220. He knew why it was that he was addressing that as the first issue, because if there was a plan, the probability was that they had lied and that they had deliberately withheld or concealed documents. And where the learned judge went wrong, we would say, is that he failed to weigh in the balance all the relevant evidence that went to that central plank of the case. And as a result, he unduly restricted the exercise he undertook. And we've touched on our second reason, but I'll just summarise it shortly.
So it's not that you say he failed to weigh all the relevant evidence. What you say is he put something into the scales which he shouldn't have done in certain respects. In certain respects, you criticise him for simply referring to what the judge below had said.
I criticise him for that, but I also criticise him for when he seeks to answer the question, his focus is on the new evidence, with one or two exceptions. And it's not on all the evidence. And if the judge had been evaluating properly or trying to answer the first question properly, he would have looked and analysed all the other evidence that I showed you this morning on that question. You know, the draft RNS in January, the new RNS after Mr. Ferguson understood that Mr. Tinkler wasn't resigning, the messing around with the minutes on the 17th of February to say something that was clearly untrue. The judge should have evaluated all of that in conjunction with the new evidence, and then answered the first question, was there a plan? So the second reason why we say he's wrong, I think I touched on this, we say it accorded a weight and significance to the findings of Judge Russell that they did not have, and which it was positively dangerous to accord them. This is the bootstraps point. The entire basis of the action was that the findings by Judge Russell were vitiated by fraud, and therefore, whilst you're deciding whether or not there has been that fraud, you can't safely assume that any issue has been correctly decided. Because if it transpires that the evidence below was dishonest, then obviously no issue has been safely decided. And you can't know that until you've undertaken the exercise of asking yourself whether there was a fraud. So to start with, as you know, we say that the only judge started with the assumption that Judge Russell was right, and that he had decided the questions correctly on the evidence before him. And the question for him was whether the new evidence made any difference. It just paid no regard to the fact that if Mr. Tinkler was right, and those findings were the product of fraud, no weight should be attached to them at all. So we say there's a circularity there, which is unfair to Mr. Tinkler. And merely considering whether the new evidence might have changed a finding procured by fraud, ex hypothesi, doesn't undo or otherwise negative the effect of that fraud. One simply doesn't know what findings the judge would have made had there not been a fraud. And the third and closely related problem with the judge's approach is the effect of the approach was to treat Judge Russell's findings for all practical purposes. I'm sorry.
When you say you don't know what findings, well, it may be you're going to come on to this. You say you don't know what findings the first judge would have made were it not for the fraud.
Exactly.
You're going to have to address that question.
I address when we get to materiality.
Yes.
Oh, when you get to materiality, of course you must look at what Judge Russell found. Completely accept that. You just don't look at it at the first stage. Was there a fraud? And we say the third and closely related problem with the judge's approach is that he, for all practical purposes, was treating Judge Russell's findings as though they did give rise to an issue of stock. unless something new came along that persuaded him that the judge was wrong. And that's the very concept that Lord Sumption made clear should have no application. So on the Mr. Justice Leech's approach, Mr. Tinkler was essentially stuck with all of Judge Russell's findings unless he could point to some new evidence that called into question that factual finding directly. And as we've seen, the judge's evaluation for almost entirety of his judgment is limited to the new evidence, or one or two exceptions, but there are only one or two exceptions. And we say the fourth reason why the judge's approach is wrong is it contradicts the rule in Hollington and Hewthorne. And the basis of that rule was set out by Lord Justice Christopher Clark in Rogers and Hoyle at paragraph 39 to 40. We can find that in the Skeleton Bundle 11, page 413.
Do you mean the authorities bundle?
Yes, thank you. So paragraph 39 is the judge rightly recognised the foundation on which the rule must now rest is that findings of fact made by another decision maker are not to be admitted in the subsequent trial if the decision at that trial has been made by the judge appointed to hear it and not another. The trial judge must decide the case for himself on the evidence that he receives in the light of the submissions on that evidence made to him. To admit evidence of the findings of fact to another person, however distinguished and however thorough and competent his examination of the issues may have been, risks the decision being made, at least in part, on evidence other than that which the trial judge has heard, and in reliance on the opinion of someone who is neither the relevant decision maker nor an expert in any relevant discipline, of which decision making is not one. The opinion of someone who is not the trial judge is therefore, as a matter of law, irrelevant, and not one to which he ought to have regard. In essence, as the judge rightly said, the foundation of the rule must now be the preservation of the fairness of a trial, in which the decision is entrusted to the trial judge alone. So we say it's for Mr. Justice Leech to make factual findings for himself, and not to place any reliance at all on findings made by Judge Russell for the purpose of deciding the issues for him. And the final and fifth point we make is the approach adopted by the judge is unworkable in practice. To begin with, it ignores the fact that it will often be necessary to make factual findings on a claim to set aside a judgment for fraud that are not themselves constituent elements of that course of action, namely conscious and deliberate dishonesty and materiality, but which findings provide the necessary background that enables those allegations to be made. It's no different from a judge having to make findings as to factual matrix on a breach of contract claim. Factual matrix doesn't represent the course of action, but it's material the judge might have to have regard to. And these sort of factual findings cannot sensibly be made if the approach one is to adopt is simply to take the judge's findings and then to look at the new evidence. Because evidence that may not have had a particular importance for the first judge on a particular issue or issues may have obvious importance to the issues the second judge has to decide when seeing whether there's a fraud. And on the judge's approach, the original evidence can't be looked at for the purpose of making a factual finding because it's not new. And then secondly, the trial judge may have made findings that overlap and are similar to the findings that the second judge has to make, but doesn't mean they'll be the same. The findings the trial judge makes will be those necessary to determine the cause of action before him. And on the judge's approach, one is stuck with the findings that are made, even if on a close analysis, they're made for a different purpose or issue. A good example of that in this case is the findings made by Judge Russell with regard to Mr. Tinkler's challenges to the propriety of the decisions made to remove him as a director. Those overlap closely with the question of whether or not there was a plan from the outset to get rid of him, but they're not the same. And on the judge's approach, one simply has to make do and shoehorn existing factual findings.
So you're reading from somewhere, but I'm...
Yes, I'm sorry, I'm going too fast.
No, you're just I just was going to try and catch up with where you're reading from.
No, I'm reading from a note, sorry. You haven't got it.
You're not reading from your skeleton?
No.
Okay, right.
So, we say what's pernicious that the judge ends up, that's Mr. Justice Leech, ends up actually shoehorning findings that were made for one particular purpose into issues that weren't before the judge. We saw that particularly with the second Laycock side letter, where the judge starts off by this is issue 6, with a long analysis of Judge Russell's findings on 89.895 before he addresses the new evidence about what was going on with the second Laycock side letter. And it's quite clear, we would say, and I would ask you to reread issue 6, it's quite clear from that section of his judgment that he's allowing his views about the Laycock side letter and the reasons why Laycock was basically persuaded to retire pro tem. That analysis by the judge is informed by what Judge Russell said. And we say...
That wasn't the first example you gave, I don't think, was it?
No, it was issue 6.
Yes, I know.
Yeah,
sorry.
the first example I gave...
Just before I intervened to ask you where you were reading from, the reason I was trying to get it is I thought you were giving us a different example, and I just wasn't up to speed with it.
Yes, I did.
And
so he made findings with regard to Mr. Tinkler's challenges to the propriety of the decisions made to remove him as the director and terminate his service contract. Now, those findings overlap closely with the question whether there was a plan to get rid of Mr. Tinkler, but they're not identical.
So, okay, I would need, speaking for myself, I would need the references to that because I'm just not on top of those references. This is the judge made findings in relation to Mr. Tinkler's reaction to being removed.
No, the justification given by Esken to remove Mr. Tinkler. It's very similar to the question whether there was a plan to oust him. It's not the same as.
Have you got some cross-references you can delete?
I'll see if I can get them to you before I sit down. If I may move on.
Yeah.
And the other reason it's unworkable, it causes problems with credibility. The judge fully accepted that he had to make findings as to the credibility of the witnesses, and indeed did so. And it can hardly be otherwise, where we were alleging that Mr. Brady, Mr. Ferguson, and Mr. Soames had given false evidence. But the problem with the learned judge's approach to that is it forced him to close his mind and leave out of account any challenge to the credibility of a witness, where that challenge wasn't based on new evidence and had been the subject of a finding made by Judge Russell. We've seen that with the Ferguson Ball minutes. And you've already seen, I referred to more than once, paragraph 10 of the consequential judgment. And we say that the judge was required to address this, even if he would have been inclined to reach a different finding on the issue before him to the finding made by Judge Russell. And the result of his feeling that he wasn't able to readdress that question is that the judge was forced to assess credibility on an entirely artificial basis, being forced to ignore his own views on credibility on an issue in favour of a judge who formed that a trial tainted by fraud, as we would say.
But going back to my previous question, on your hypothesis, what the second judge should do is to form his own view on credibility, but then he has to decide whether that would have been different if he did not have the material related to the material that was concealed, doesn't he?
I don't think so. I think once he's decided that he doesn't believe, say, Mr. Ferguson, and let's say he goes on to say the reason Mr. Ferguson...
Yeah,
sorry.
Let's work... The hypothesis is the first judge has believed Mr. Ferguson.
Yes.
Second judge says, actually, I didn't find Mr. Ferguson a credible witness. I disbelieve him.
Yes.
I would reach a different conclusion on a relevant issue because of not believing Mr. Ferguson. The judge then, on your hypothesis, the judge has to decide, is the reason I didn't believe him?
No. No, not at all. It just then just has to consider materiality, which is just that either...
Well, hang on.
But I come back to your answer to my question. You said the new evidence does have to be relevant to the issue of fraud. Relevant in what way? Because your last answer suggests that it doesn't have to be relevant at all.
Well, I don't think you could issue a claim in fraud which just referred to immaterial and obviously irrelevant new material and do that just with a view to trying to reopen the original findings of fact.
Leave aside obviously irrelevant. Let's say it's contended to be relevant, but the judge doesn't find it to be persuasive. He disbelieves Mr. Ferguson, hypothetically, based on a complete rerunning on the old evidence. But he takes the view that the new document, which justifies the exercise in the first place, doesn't really influence him at all in reaching that conclusion. What happens then?
Well, it's a very different question. I mean, I can see arguments both sides. I can see someone saying in that event you don't make out your cause of action because you have not got home on any new material, and having new material is essential part of the cause of action.
This is, I find this one of the perplexing aspects, because the structure in which the ingredients are often listed is 1, fraud, 2, materiality, 3, new evidence, as if new evidence is simply a separate category as a threshold, and provided there's some new evidence, you just do limbs 1 and 2. Speaking for myself, I find that rather surprising and contrary to what was said in Highland. But what I'm having difficulty with is where in your analysis the relevance of the new evidence comes in.
Well, I would say that the new evidence has got to be relevant to the question of fraud.
But what do you mean by that? Relevant in what way?
It's got to help
the judge has got to have relied on the new evidence to some extent,
yes,
in determining that there has been fraud.
Yes, what I would say.
So going back to my example, if the reason the second judge doesn't believe, we're using Mr. Ferguson here, which we probably shouldn't, but so we have a witness that the second judge doesn't believe, contrary to the view of the first judge. If the reason or if a contributing reason that the second judge, having heard the evidence afresh, doesn't believe him, is because of a point which was not actually run at the first trial at all, that's what causes him to disbelieve.
But not the new evidence.
But not the new evidence. Then,
well, I think in those circumstances, if the judge is convinced that the new evidence does not impact on the question of fraud, then I think I'd be forced to accept that in those circumstances the second judge is to say that cause of action is not made out, and even if I might have reached different views to credibility to the original judge, that's the end of the matter. So it's quite clear from this jurisdiction that you can't rerun trials because you don't like the results.
Well, so the issue the problem with credibility is that on any view the judge has to perform the exercise, having reached a different conclusion on, say, credibility on an underlying issue.
Yes.
Has to decide why, and has to relate that in some way to the new evidence.
Exactly. How does this fit with the new evidence? Now I've seen the new evidence and I'm now looking at revisiting the manipulation of the minutes. Am I now satisfied that Mr. Ferguson was lying?
So that will inevitably cause him to have to compare his answer, his result, his reasoning, with that of the first judge.
Only when he gets to materiality. When he's assessing the evidence, he looks at all the documents he's got before him. He looks at the documents put to Mr. Ferguson, and he makes up his own mind.
I mean, I just don't understand why all that happens when, you know, the classic statement seems to be Highland, and Highland gives a very simple path. It says first there has to be conscious and deliberate dishonesty in relation to the relevant evidence given to the first judge, or action taken, or statements made, or matters concealed, which is relevant to the judgment now sought to be impugned. So the first question is to show there was conscious and deliberate dishonesty in the statements made to the judge.
That's what I thought I'd been saying.
Yes, well that's the first job, not retrying the issue before the first judge, but the evidence given or actions taken or documents concealed was done dishonestly. And then the second question is, and all the rest of the analysis is on materiality.
Yes, but I don't think the first question, though, might necessarily require the second judge to revisit factual issues that were dealt with first time round.
Sorry, what did that just...
Would necessarily require the second judge to revisit factual issues.
It does or it doesn't?
It does.
Why?
Depends on the case.
No, but why? I mean, why don't you just ask whether there was conscious and deliberate dishonesty in relation to the relevant evidence given to the first judge, or action taken in front of the first judge, or statement made to the first judge, or matters concealed from the first judge, which is relevant to the judgment impugned?
It begs the question of what material you rely on when answering that question. All I'm saying is the judge, when answering that question, must look at relevant material that goes to that question, and that's all we've ever said. We're not, there's nothing more subtle. There's nothing subtle about our submission about that.
Well, in fact, what you actually say is he asked himself the question, is there a risk that I've reached a different conclusion from the first judge on the basis of the new material?
No, I'm saying he must start off by asking...
Yes, but when he gets to materiality...
Well, then that's the Highland versus Hamilton debate, which I'll come to very shortly. And that's the question
But
of
I think, sorry to interrupt you, I think you are saying there's something different at that very first stage before you get to materiality, which is not only has there been a fraud, but is it a fraud that I have concluded has taken place by reference, at least in part, to new material?
Well, I think so.
Otherwise, so you're adding that ingredient to Lim 1.
Well, I think so. I mean, I don't see how you can set aside a cause of action obtained by fraud if you're unable to deploy any new material not deployed below that doesn't go to that. Otherwise you're stuck in finality of litigation and rerunning arguments. And as we know, you're not allowed to do that. And the jurisprudence can't be, oh, you can come along with any old piece of new evidence and say, aha, I'm now rerunning the first trial. It's certainly not how we put it.
No, I mean, I understand that. Otherwise, it's a gateway which is so wide.
Exactly.
It's hardly a bar at all.
Exactly.
Having a second pop.
So it's got to be material. The new evidence has to be material to the question of fraud. I accept that. And I never said anything. I don't think I've ever said anything contrary to that.
It has to be material to the question.
Or relevant. Not sure I draw a distinction between the two. So, in making, just before I finish issue 1, being conscious of the time, in making that submission good, it's necessary for me to address briefly the reasons the judge gave in his judgment, in his consequential judgment, why he wasn't prepared to adopt the approach we were arguing for. And we submit that none of the reasons he relied on provide a sound basis in principle or practice to reject Mr. Tinkler's proposed approach. First of all, the judge in paragraph 37 of his judgment, at page 104, let me in paragraph 37, paragraph 33 of his judgment, at page 103, seems to be concerned that he might reach different conclusions. To the conclusions reached by the original judge. And we say he was wrong to be so concerned. And we say that because as a trial judge, all that should have mattered, and all that did matter, was the evidence that was before him. That the parties may have chosen not to put before him all the evidence they put before Judge Russon was their forensic choice. We would submit it was the judge's job to hear the evidence the parties did choose to adduce, and to make findings based on that evidence insofar as he felt able. He didn't need to worry that those conclusions might be different to those of Judge Russon, because he was trying a completely different cause of action. And I've already explained why we say no deference was due to Judge Russon's conclusions, because at the least the possibility that they were obtained by fraud. And the judge seems to also then have thought, as we've seen from paragraph 8 of the consequential judgment, that any other approach was unworkable. And as we say in our skeleton, we really don't understand that, because at the time-honoured approach, look at the evidence and answer the questions you're asked answer should have been straightforward on the material before him. So we say, for all the reasons I've articulated, the court should allow Mr. Tinkler's first ground of appeal. Before moving to grounds 2 and 3, I would like, at speed if I may, just to answer some of the points that my learned friend makes. First of all, my learned friend says at paragraph 6 that our principal submission treats what were merely passing observations as fundamental statements of approach. And we say that's a brave submission. Mr. Justice Leech made it perfectly clear that he was concerned with a fundamental statement of approach, a point he repeated at the consequentials hearing. He did this at my learned friend's instigation. And that being so, we would submit that it takes some front for my learned friend now to say that the judge didn't in fact do what he invited him to do, and what the judge also said he was doing. He then goes on to say at paragraph 18 that the structure adopted by the judge, whereby he set out the Judge Rustin's findings first, was a coherent and sensible one to contextualise the new evidence. And we say, as you know, that that's the wrong approach. He then goes on to say in the next paragraph that the judge made his own findings about credibility. I accept he purported to do that, but only in relation to the new evidence, having tied one arm behind his back by looking solely at the new material and saying that where there was no fresh evidence in relation to a particular issue, it wasn't open to him to question Judge Rustin's findings. And then at paragraphs 22 and 23, my learned friend says this ground of appeal is all based on a misconception that actually the judge was concerned with materiality. The problem with that is that this is simply not what the learned judge said or did. As to what he said, I've already taken the course of the judge's judgment and how he deals with the question of materiality and the new evidence requirement. If we go back to tab 7 of the core bundle at page 98, we can see at paragraph 20 onwards the judge dealing with materiality, that's 23 to 26. And those paragraphs all concern the difference between the test in Hamilton and the test in Highland. And there's no mention at all of the issues which we're concerned about on this first ground of appeal. And those issues are only introduced for the first time at paragraph 27, which is limb 3. My learned friend then alights on the phrase, stand in the light of that evidence, which is in paragraph 33, which is I've already taken you to. But it's quite clear that the substance of what the judge is talking about there is the task he has to undertake to make findings in respect to the new evidence. And it's plain that my submissions that he records in the previous paragraph, that's paragraph 32, are nothing to do with materiality. That the debate was limited to the extent to which it was open to him to reach conclusions that differed from those reached by Judge Rustin. And his conclusion about that, as you've seen, is at paragraphs 33 and 34. And my learned friend's submission about this is flatly contradicted by 34, where the judge says, the task for me then is to hear and evaluate the new evidence, decide whether limb 1 is satisfied. And that's a point that you know the judge repeated at paragraph 221. And it's also clear that what the judge did was not concerned with materiality. I've already taken to you the example of issue 1, and the findings he makes on issue 1 end up at paragraph 235 on page 186 of the judgment. Sorry, start at page 235, 186, and then that analysis continues to 255 on page 186. Sorry, I gave you the wrong reference. And after 255 on page 198, he deals with dishonesty, and then he ends up dealing with materiality at paragraph 286 of his judgment, which you find at page 208. So it's quite clear that the observations he made in respect of limb 3 had nothing to do with materiality, although as I've already pointed out, he seems to have relied on what Lord Justice Esken said in respect to materiality to support his conclusion. My learned friend then complains at paragraph 25 we don't provide any concrete examples. I've already done that. He points to one example at paragraph 236 of the judgment, where he says the judge does consider the issue by reference to one document that was before Judge Russon. The trouble is about paragraph 236 doesn't show that the judge was deciding the issue by the totality of the material before him. All he was doing is looking at a bit of old evidence that was contemporaneous with a bit of new evidence to understanding the meaning of the new evidence. And then my learned friend seeks to rely in paragraph 26 of Skeleton on paragraph 220 of the judgment, where the judge says he shouldn't shy away from making findings on issues properly before him that were similar to those determined by Judge Russon. The judge does indeed say this, but the problem is the way in which he decides he should make those findings, i.e. by looking at what Judge Russon found, accepting those findings as being unimpeachable, and then just seeing whether they're put into question by the new evidence, is the wrong approach and doesn't answer the gravamen of our complaint. And then my own friend develops a serious submission by the reference to the pleadings, but I think I've already made it clear. We pleaded our case properly as to the plank, central part of our case being the plan, which feeds into the reason why documents were concealed or destroyed or withheld, and feeds into why they misled the court. And then my learned friend goes on to say that that we're not able to traverse credibility, but matters of credibility don't have to be pleaded, and that is common ground. And my learned friend, no doubt, will try and make much of the fact that we refused permission to amend on a couple of points, but we can't be in a worse position than we would have been if we hadn't sought permission to amend. It's open to us to cross-examine about their defence. Their defence was that there was no plan and they only ever intended to use 89.5 as leverage. We're entitled to ask questions about that. Importantly, the one passage of my learned friend's submission that I'd like you to look at is paragraph 32, which you find in tab 17 of the second core bundle. And then a friend says in paragraph 32, second sentence, where an issue is squarely within the scope of the present claim, it falls to the present judge to determine it on all the materials available to him or her, new or old, regardless. That wasn't the position as we understood he was adopting below. I see the time. I need to go and move on to my grounds 2 and 3. Obviously, I may need to come back to my learned friend's points tomorrow. Ground 2 is this. It was common ground that the conscious and deliberate dishonesty relied on must have been material to the original decision. And Mr. Tinkler's second ground of appeal is concerned with the correct test for materiality. And as the court will have seen, there are diverging authorities about this. First of all, the starting point is probably the judgment of Lord Justice Esken in Highland, tab 10, page 341. And deals with materiality halfway down the page. Can I treat that as read or?
Treat that as read.
Thank you. And we say that puts the bar too high. That's because it was based on the decision of Hunter. And as we know from Lord Sumption's judgment in Takar, that Hunter is not the correct approach when looking at this area of law. And we can see that at tab 15, page 833. paragraph 65. And at H, having considered Hunter, Lord Sumption, part of the majority, I respectfully decline to treat the statements in those cases applying to proceedings to set aside a civil judgment, and would hold that the dicta in 2 Owens Banks cases were mistaken. And Lord Kerr reaches the same view at page 826. At paragraph 39, he says the context of Hunter is firmly set. It's whether a challenge to the correctness of a criminal conviction amounts to an abuse of process. And at 42, over the page, the rule is therefore expressed to apply where there's a proposed re-litigation of the issue of fraud, which should be determined. That's not the case here. And we say the correct test was as stated in Hamilton, and you'll find that at tab 4 of the authorities bundles. And
in paragraph 65, sorry, I'm trying to keep up here.
Sorry.
Paragraph 65 that you've just taken us to, Lord Sumption, what's the issue he's actually dealing with here?
The question is whether or not there's a reasonable diligence requirement, and the old authorities assumed from Hunter that there was, and he held that Hunter wasn't applicable.
What's that got to do with middle of paragraph 106 of Highland?
Because paragraph 106 in Highland was a test agreed by council, which is based on the language of Hunter, on the assumption that Hunter was good law in this area.
Sorry, when you say... Sorry, how do
we know that?
Yeah.
Because Hunter's not mentioned in Highland.
I can't join the dots.
Can I keep going and then answer your question? Because I think it will be answered.
Well, I think the footnote in Highland is to the decision of Mr. Justice Langley at first instance in Odyssey Re, which contains, it's called Odyssey Re, it's Fairdrake and Orion, but Odyssey Re on appeal.
Which has a very long
analysis, but doesn't rely solely on Hunter by any means.
Well, it
really
rejects
quite a lot of authority, including Genesco and Lord Buckmaster and so on. So,
but he rejects that line of authority that Lord Sumption relied on. So in the sphere, in the Orion case, Lord Sumption said that the correct test was based on Genesco, etc., MacDonald and MacDonald, and the judge rejected that and went down the Hunter path and said Hunter was good law. And the oddity about all of this is when we get to the Supreme Court in Tackar, they reject the Hunter line of authority. They say, yes, Genesco and Hipfong, etc., and MacDonald are the correct cases to look at and tell us what the true answer is. But then they still refer to Highland, and I'll explain why they do in a moment. They still refer to Highland, even though Highland's...
I'm being really, really dense, and I'm sorry about this, but paragraph 65 is dealing with the requirement for reasonable diligence.
Yes.
And everything that's said there, including the declining to treat the statements in the 2 Owens cases as relevant to civil judgment, is all to do with the question of whether evidence could with reasonable diligence have been deployed, not with the question of materiality.
Can I take you then to Hunter itself?
Sorry, am I wrong in what's paragraph 65?
No, it is absolutely the focus of 65 is Hunter in relation to the due diligence test. But Hunter, as formulated, also feeds into Lord Justice Aitken's observations in Highland, and it's quite clear it does. If I take you to Hunter itself, can we look at page 545? Page 143 of the bundle.
Lord Diplock.
Yeah. Apologies. So, B through to D, he's Lord Diplock is agreeing with Lord Justice Goff. And at C, you'll see he adopts the proper test that laid down by Earl Kearns on phosphate sewage, namely that the new evidence must be such as entirely changes the aspect of the case. Now that's the phraseology you see echoed in Highland. And he goes on and he's saying he agrees with Lord Goff.
Sorry, but this is dealing with two separate questions. The first between B and C is dealing with the reasonable diligence point. The second between C and D is dealing with a different point, namely the materiality question.
Yes.
Right.
And that's...
And in paragraph 65 of TACAR, the reference to Hunter is the first bit of this paragraph between B and C.
Yes. But the entirely changed aspect of the case, we say is applicable when you're dealing with second limb of Ladd and Marshall and there's no question of fraud.
Yeah, but sorry, I thought you took us to paragraph 65 of TACAR to show us that Lord Sumption disagreed with the treatment in Hunter of the materiality question. And I'm just not getting that from paragraph 65. Lord Sumption is dealing with the reasonable diligence test.
He is, but he's doing it on the basis that Hunter has no application to this area of law.
Well, I mean, the Hunter's at C, on the page 143, talks about Lord Justice Goff, and as my Lord says, deals with whether the evidence would have been reasonable diligence had been available before, and then says Lord Justice Goff also examines the two suggested tests as to the character of fresh evidence. It's a completely different point, right? And there's nothing in paragraph 65 of TACAR that says he's saying anything at all about that second aspect. That's the point my Lord's making.
I mean, at 545E, Lord Diplock proves Lord Justice Goff as saying, in relation to the test where you've got a collateral attack in a court of coordinate jurisdiction, as being different from and more rigorous than the test where you're on an appeal, and it is the test laid down by Earl Cairns.
Yeah.
And that is the entirely new aspect. So that is Lord Diplock saying, change the aspect of the case is the right test.
Yes.
For setting aside.
Yes.
And there's nothing, is there, in TACAR that says anything about that in relation to materiality.
Give me a moment.
Did you say no in answer to my Lord?
I think you said yes so far as Hunter was concerned.
Yeah, I just want to show you.
And I asked you whether there was anything in TACAR which, or materiality, which suggests otherwise.
Can I show you paragraph?
Question.
Didn't mean to cut across you. Sorry, paragraph page 824. Paragraph 34, Lord Kerr refers back to the phosphate sewage case, which we've just seen relied on by Lord Diplock. And so, bottom 34 on that page, plea raised judicata succeeded because the company had the relevant knowledge. And then he says the contrast to the present case is immediately obvious. Not an instance of the claimant seeking to deduce evidence of facts going the same direction. And then at 37, Lord Justice Patton acknowledged Earl Kearns' statement, but he suggested the rule expressed by Earl Kearns to be relevant more generally as a statement of the conditions which must be satisfied to justify departure from the policy of not permitting a party to challenge prior decisions by a court of competent jurisdiction, in which case it's relevant as to whether it be an abuse.
This is all to do with reasonable diligence again,
Yes,
isn't it?
it is. You're right.
So,
I thought I've got... Let me take you on to Hamilton, and I'll come back to see if I've got a better reference. There's something I'm afraid I lost sight of, where there's a discussion of the second rule in Ladd and Marshall, and it's made clear that it's not applicable to a case where one's seeking to set aside judgment obtained by fraud.
Well, indeed, that's what Lord Diplock says.
No, was Lord Diplock was.
Lord Diplock saying the tests aren't the same. That's the more rigorous one.
Yes, but he's making it even more rigorous. Can I just show you Hamilton to see whether I get there? It's the Court of Appeal decision, which you find at tab 4. Can we start at page 94?
Sorry, I've been trying to keep up with you. Hamilton, sorry, page.
It's page 94 of the bundle. Paragraph 15. Sometimes an appellant relies upon fresh evidence that was fraud when this evidence puts the result of the trial in doubt, but that doesn't go as far as to demonstrate the result was probably wrong. In such circumstances, the requirement of Ladd and Marshall is not satisfied. The authorities indicate, however, that provided fraud affecting the trial is clearly established, the retrial may be ordered notwithstanding this. Then they cite from Lord Buckmaster in Hip Fung. And then he goes on to 17, Lord Buckmaster returned to this theme in Genesco and Beard. In that case, the Court of Appeal reversed the trial judge on the basis of fresh evidence adduced by affidavit that challenged the account of the material facts given by the successful defendant. House of Lords concluded the Court of Appeal had misunderstood the evidence, restored the decision, and cites from Lord Buckmaster saying, long settled practice, proper method of impeaching a judgment, etc. Then 19, the distinction between the criteria justifying an order for a new trial on the grounds of fresh evidence and the criteria justifying an order for a new trial on the grounds of fraud was illuminated by judgments in MacDonald. And one could pick it up under the heading Fraud and Causation on 97, in paragraph 26 of the judgment. Court says a new trial should be ordered where the interests of justice so demand, where parties behave fraudulently, being guilty of procedural impropriety or some other irregularities affected the fairness of the trial. The vital question to be asked is whether there's a real danger that this influenced the outcome. If there is a
Where does that come from?
And the conclusion, 34, on page 100, where no deception has been involved, fresh evidence as to credit will seldom, if ever, be admitted, for such evidence will not normally satisfy the second requirement of leading to the conclusion that the decision appealed against was probably wrong. Secondly, where it's clearly established by fresh evidence the court was deliberately deceived in relation to the credibility of the witness, a fresh trial will be ordered where there's a real danger that this affected the outcome of the trial. And the judge dealt with this in paragraphs 22 to 24 of his judgment.
Sorry, I didn't hear the answer to my lord's question. Did I not?
I may have forgotten to answer it. I apologise.
Well, my lord asked you where those words come from, other than out of the then Marshal the Rolls' mouth. I mean, where does he get the test from? The real danger test.
It comes out of his assessment of the decisions in Hip Fung, Genesco and Beard, and MacDonald and MacDonald, which you've seen on paragraphs 15 through to 19.
None of those cases are in the bundle, are they?
No, but they were all considered in TACAR.
I mean, TACAR's a wonderful case, but it's about a completely different point.
Exactly.
I mean,
That's the ground two in a nutshell. I'll get there in a moment.
all right.
But sorry, so where's the real danger wording test in the narrative of the decisions in Hipfong, Jones, Nesco and Beard, or MacDonald and MacDonald. I just can't see it. I'm being, again, just slow, but where?
Well, I'm ahead
judgment, sorry.
I'm ahead of you because I've done a search for the word danger throughout this bundle of authorities, and it doesn't appear before Hamilton and Al-Faid.
Have a look, please, at the last two lines of the quote in paragraph 15. Judgment that's tainted by fraud and affected by fraudulent conduct is tainted throughout and the whole must fail. Not looking at causation, it's looking at is there fraud here.
Sorry, 15.
Paragraph 15 on page 95. It's the quote from Lord Buckmaster in Hipfung.
Yeah, my Lord's question, which I'm sorry, I was just trying to get the answer to, was when you went to Lord Phillips's summary at either 26 or 34, and he said a fresh trial will be ordered where there is a real danger that this affected the outcome of the trial. So in other words, assume fraud. What's the test of materiality? You were asked, where does this test of, quote, real danger come from? I can't see it in any of the other authorities to which he refers. It just seems to be his words.
I think it's the court's interpretation of what Lord Buckmaster was getting at, and I think it also comes from MacDonald and MacDonald in paragraph 19. Paragraph starting, but if the fresh evidence doesn't satisfy all these requirements.
But Lord Buckmaster doesn't say that. Lord Buckmaster says at the top of page 95 that it's not sufficient to show the applicant must go further and show that the evidence was of such a character that it would, so far as can be foreseen, have formed a determining factor in the result.
Which paragraph are you reading from?
I'm reading from the quote from Lord Buckmaster in Hipfong. Is that right?
No, I don't think it is.
That's where he says if there's no charge.
If no charge, exactly. That's the distinction being drawn.
So he says, but where does he say that then there's a different test?
But the last two lines of that. And MacDonald and MacDonald adopt the same approach in the last half of that quote, saying if the fresh evidence doesn't satisfy all these requirements.
Well, sorry, are you saying that Lord Buckmaster was saying that seems to say if there was some fraud, the whole judgment is tainted and it doesn't matter whether the result would have been different at all?
Exactly.
So he's saying there is no test of materiality at all?
No, well, it's material if it's tainted by fraud, full stop.
Well, if you show the judgment, if there was fraud in the proceedings, let's put it this way, which led to the first judgment, the whole thing is tainted. It doesn't matter whether a different result would have been achieved.
Which is why I think we end up with the real danger, because if we read MacDonald and MacDonald.
I think we can get it perhaps most clearly out of Mr. Justice Langley's judgment in Spare Drake.
Thank you.
Behind tab 13.
Thank you.
Starting at 596. Where first in the middle of the page there's a quotation from Lord Buckmaster in Genesco.
Yes.
Which is, fraud is an insidious disease. I'm looking at the last three lines.
Thank you.
If clearly proved to have been used so it might deceive the court, it spreads and infects the whole body of the judgment. And then over the page, Mr. Justice Langley refers to Lord Justice Phillips' judgment in Guylamer, where he says, last three lines of the first half of the quote, I do not think it's clear on the authorities the parties seeking to set aside a judgment must go as far as show it on the balanced probabilities the judgment would not have been given but for the fraud. Justice Phillips refers to Genesco. What's the proper test? Fraud must be such as to put the validity of the judgment in doubt.
Yes.
And then there's a reference to MacDonald, which picking it up just above the quote on 598.
Yes.
Seems to say it's not necessary, it should be found to be probably conclusive of those issues.
Yes.
And then as I understand it, what Lord Phillips, as he'd now become in Hamilton, was doing was drawing on that to use a phrase that I certainly haven't seen
Yes, and if
Anyway,
we
before serious risk. Is that?
yes,
is that
I'm very grateful for that. And before we leave that case, can I just remind everyone about 598? Because the judge there says no easy distinction between these two lines of authority. And he says, in my judgment, the judgments and tests in Hunter's case are to be preferred, and in particular, as expressed in the words of Lord Kearns, that the fresh evidence must be such as entirely changes the aspect of the case. Which is why I was saying that that feeds into the Highland test. That's effectively the language used by Lord Justice Aikens in a test agreed by council.
No, it certainly feeds into Highland. Hunter, the second point in Hunter made in the passage we poured over, is it feeds into Highland. Of course it does.
Yes.
And Lord Justice Aikens footnotes this decision of Mr. Justice Langley as the authority for the proposition that he cites.
Yeah.
So since Hamilton, there have been two Court of Appeal decisions where obiter, the court, has preferred the Hamilton test. First is Sally Kapoor, which you'll see at page 446. Paragraph 93.
But where it wasn't fully argued, does it really matter?
Well,
I mean, it's persuasive.
it's persuasive. Here's a Court of Appeal. It was the then Master of the Rolls.
In both cases.
Yeah. And then we've got a third. We've got a case and my lord was involved in. Where
I thought that was the one you were referring to.
No. Sally Kapoor is Sir Terence Etherton, paragraph 93.
Yeah, I understand.
They prefer it. And then there's a decision of the judgment of the court in Terry and BCS. I don't know whether this has reached you. It was a case my lord was involved in.
Indeed, yeah.
And again, the same preliminary
exactly
view is expressed.
Both cases, we don't have to decide it, but if we did, we'd be inclined to say it's a
Well, if you're with me on ground one, I would ask you to decide this.
Do we have to decide it here? What's the point in deciding it? The judge reached a conclusion on both tests of materiality.
But the judge proceeded on the basis that the two tests were the same, and they're clearly not. So,
well, the judge said he didn't see the distinction, rather than that the two tests were the same. I mean, they're plainly not the same. They're different words.
Well, I think he did say that the two tests were the same. He said there was no, if you look at paragraphs 22 to 24 of the judgment, there was no difference between the two tests.
Well, he purported to apply both tests,
But
and he made his factual findings on materiality, which are all clearly set out. And speaking of myself, they seem to be conclusions which are that on these facts it doesn't even meet the Hamilton test.
I'm not saying his finding, my appeal is on ground one. I'm saying that if he had approached a proper approach, if you're satisfied he didn't apply the proper approach to ground one, all his findings of fact are unsound, and therefore we don't get to a debate about materiality.
So this is all very interesting, but not very important, because what he actually said in 22, which I think is rather clear, is I'm not satisfied. There's a real distinction in practice between the two tests. And so for the avoidance of doubt, and in order to be bomb-proof on appeal, he said, I'm deciding both.
Yes.
So if you win on ground one, you win, and if you lose on ground one, you lose.
Yes. I did say that, I think, at 10:35.
But then this is all very interesting. I mean,
but sorry, is that right? Because
Yes.
I thought that ground two, which addresses materiality, involved findings by the judge which were on the hypothesis that he was wrong on dishonesty and that there had been dishonest conduct. And he said, if I'd been persuaded that there'd been dishonest conduct, with one exception, I think, in relation to one of the non-disclosures, it was not material.
He doesn't adopt the hypothesis if he had found in favour of Mr. Tinkler's case, I would have found X, Y, and Z. He just approaches on the very limited basis of the findings made on the basis of the new evidence. He doesn't say, if I'd found there'd been a plan and it wasn't, and they'd lied to me, I would have found not material. Doesn't do that.
so you say that the first part of what I put to you, namely if you win on ground one, you win, is correct.
Yes.
My lord was putting to you that if you win on ground one, you still don't win.
No, well, I was disagreeing with my lord.
You were. Very clear.
I don't know whether I need to develop that any further.
Well, we've taken up more of your time, or I have anyway, and I should have done. So don't let me deflect you further. I can
These things happen.
chase
It's
that
all
up.
fun of the game. So, doesn't sound as though you're very interested in ground two. I mean,
I'm extremely interested. I think it's one of the most interesting points, I'm sure, for an article in the Law Quarterly Review. And I expect to see your
damning with faint
that
praise
article
now.
shortly, Mr. Wardell, with your name on it.
I would have thought that this court, if it minded to grant the appeal on ground one, might want to give guidance on the correct test. But
I think we'd be inviting an appeal to the Supreme Court.
yes, you probably would. Anyway, can I just, as a postscript point about TACAR, because a lot of first instance judges have placed very heavy reliance on what was said in TACAR about Highland. And all I'd say about that is this. Hamilton, Sally Kapoor...
You say it wasn't argued.
Wasn't argued. I mentioned it in passing in my oral submissions. None of those cases were opened.
Oh, of course you were there.
I was there. So, you know, if you want for completeness, I did refer to this distinction in my written case. All the three.
I mean, I think ground three.
Ground three. Thank you.
6 minutes for ground three.
Yes.
I think you accept it even in your argument that ground three is not conclusive.
Well, I'm not going to win on ground three if I lose on ground one. So,
Right.
6 minutes. So, paragraphs 25 to 26, the judge accepted Esken's submission in reliance on paragraph 46 of the judgment in Cochran and Bailey that where it's alleged a witness gave false evidence, the question is not how the judge's conclusions would have been affected by the knowledge that a witness was not frank and straightforward, but how those conclusions would have been affected if the witness had provided the information which is alleged to be concealed. We say that approach is completely contrary to the decision of the Court of Appeal in Highland, which part of the decision we don't disagree with, where Lord Justice Aikens, in the passage you've already seen, the question of materiality, he says, of the fresh evidence is to be assessed by reference to its impact on the evidence supporting the original decision, not by reference to its impact on what decision might be made if the claimant retried on honest evidence. Can you also look, please, at paragraph 141 on page 351. And we pick it up at about 8 lines in, just below E. First, I agree with the analysis of Mr. Justice Langley and Sphere Drake that the materiality of the fresh evidence or the new facts relates to whether the original judgment is thereby impugned. It's not for the judge considering this issue to retry the question of the liability of the parties or to see whether the fresh evidence or new facts is material to the final result, in the sense of what the decision might be if the matter were to be retried with honest evidence. And for your note, Mr. Justice Steele in the Kuwait Airways case reached the same conclusion. That's tab 7, page 211, paragraphs 198 to 9. I'm not going to ask you to look at that. And the approach in Cochran caused the judge to do the very thing he shouldn't have done, to consider how Judge Rushton's conclusions would have been affected if the witness had provided the information said to be concealed, is in effect to try it on honest evidence or assess it with honest evidence. And the judge went so far as to consider what decision Judge Rushton might have made. And the judgment is littered with examples. In the time available, can I just give you some paragraphs for your notes? Paragraphs 2871 to 3 on page 208. Paragraphs 2876 to 8 on page 209. Paragraph 432 on page 286. Paragraph 437 on page 288. And paragraph 459 on page 299. Perhaps we just took a look at one of those. can we look at page 288, paragraph 437, where it says at line 3, it's not relevant to consider how the judge's findings would have been affected if he'd known that Mr. Ferguson was not a straightforward or frank witness. And we say that's completely the wrong approach, inconsistent with the authorities, and we note in passing that the judge on the retrial in Tucker adopted the right approach. And just for your note, that's tab 16, paragraph 55, I think 120 and 137. And we say, as with the first ground appeal, nothing said by the learned judge, whether it was in his judgment or the consequential judgment refusing Mr. Tinkler permission to appeal, answers this point. He says that Highland supported his approach, and this is set out in paragraph 60 of our skeleton, but he doesn't explain why Highland supported this approach. He then says he didn't follow Coughlin without qualification, but that doesn't matter. In following Coughlin at all, he was adopting an approach contrary to Highland. When there's no answer to say that findings made by following Coughlin were not determinative, he found no evidence of fraud, because we say that finding was the product of the erroneous approach on ground 1. And the distinction my learned friend seeks to draw between perjury on the one hand, or dishonesty that's subject to the Highland approach, and perjury that isn't, we say isn't borne out by authority. Give me 10 seconds, if I may, just something I might be asked to do. Right, I think Lord Justice Snowden finally asked for references to overlap, and I think Judge Russon considered the propriety of the exercise of powers by the majority as part of issue 4 of the 2018 claim, and that overlaps with issue 1 in our claim, because the proper purpose was in issue in the 2018 proceedings.
That was issue 4A that you showed us at the beginning, was it? Yeah.
Yes, and it fed through into what happened in June as well.
Thank you very much. We will see you all tomorrow. Thank you.
It's 10 o'clock.
10 o'clock.